Can a private individual in Canada commence and conduct a prosecution? I'm going to give a brief overview of that today on Don't Talk TV and explain how private prosecutions work. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. I've had a number of viewers ask me about private prosecutions. I want to thank you very much for taking the time to watch my videos and post questions in the comments section. And I also want to try to respond to any questions, so I'm going to take today to give a brief rundown of Canada's law on private prosecutions. So, as with anything dealing with our rights and obligations as Canadian citizens, it's important to understand that we have the right to lay private prosecutions. And in fact, the right of private citizens to lay prosecutions has been called a valuable constitutional safeguard against inertia or partiality on the part of authority. So given the importance of this, the relevance of this video I think speaks for itself. So I'm going to start by giving just a brief background on the history of private prosecutions in our law, and then we'll go through the sections of the criminal code that lay out the procedure for bringing a private prosecution. Now, the right of a private citizen to lay an information and the right and duty of the Attorney General to supervise criminal prosecutions have both been described as fundamental parts of our criminal justice system. This goes back to the Middle Ages. Obviously, Canada didn't exist back then, but we draw our law from the laws of England, and the laws of England found their genesis in the Middle Ages. Under English common law in that time period, crimes were regarded as being committed not against the state, but against a particular person or family. It therefore followed that the responsibility for bringing the prosecution to court would fall on the individual who had been wronged. And it was a particular feature of English common law that it was not only the privilege but the duty of citizens to preserve the king's peace and bring offenders to justice. So this common law foundation for the laying of private prosecutions led to its codification in the Criminal Code of Canada. And what I'm going to focus on are the current sections of the Criminal Code that were instituted as part of amendments brought in 2002. And although the Criminal Code nowhere expressly authorizes private prosecutions, it's clearly implicit in certain sections that indicate that any person can lay an information. So specifically, the sections of importance to us here are going to be sections 504 and 507 of the Criminal Code. So I've got the Justice Law's website open here to the Criminal Code of Canada under Part 16, compelling the appearance of accused before a justice and interim release. And as I indicated, Section 504 is the section of importance here, and it indicates that anyone who on reasonable grounds believes that a person has committed an indictable offense may lay an information in writing and under oath before a justice, and the justice shall receive the information where it is alleged, A, that the person has committed anywhere an indictable offense that may be tried in the province in which the justice resides, and that the person, 1, is or is believed to be, or 2, resides or is believed to reside within the territorial jurisdiction of the justice. And by the territorial jurisdiction of the justice, that means the province. So an information doesn't necessarily have to be sworn in the same city as where the person being accused resides, but it has to be sworn within the same province. Now, once an information sworn on oath has been accepted by the justice, Section 507 then imposes certain obligations. So specifically, Section 507.1 sub 1, referral when private prosecution. So a justice who receives an information laid under Section 504, that being the section we just read, other than an information referred to in Section 507 sub 1, shall refer it to a provincial court judge or to a designated justice to consider whether to compel the appearance of the accused on the information. So the laying of the swearing of the information is just part 1. Then you have to get a judge to agree that that person should be compelled to come to court and answer to that charge. So, subsection 3 lays out the conditions for issuing a summons or a warrant to require someone to come to court. The judge or designated justice may issue a summons or warrant only if he or she A. has heard and considered the allegations of the informant and the evidence of witnesses, B. is satisfied that the Attorney General has received a copy of the information, C. is satisfied that the Attorney General has received reasonable notice of the hearing under paragraph A, and D. has given the Attorney General an opportunity to attend the hearing under paragraph A, and to cross-examine and call witnesses and to present any relevant evidence at the hearing. So the hearing and considering of allegations requires that evidence be called. So private information, you can't simply go to the court and say X did Y, and therefore I want you to issue a summons. You have to back it up with evidence. And evidence isn't just simply hearsay, oh, I heard this, or I saw in the news that they did that. You have to bring witnesses to court. They have to testify under oath as to their observations. So in order to present a private prosecution, you have to back it up. You have to do the investigation first, prepare the evidence, and be prepared to present it to court to convince that judge that they have no choice but to issue that summons. And this is especially the case when we're dealing with that inertia or interest I referred to earlier. And it especially would apply if any individual were trying to bring a private prosecution against some sort of public figure or someone with a certain amount of power. There has to be evidence backing it up. A case well worth reading for further information on how these sections of the Code are applied is Her Majesty the Queen into McHale, 2010 ONCA 361, so the decision of the Ontario Court of Appeal. That case also reiterates the long-held common law principle that the Attorney General or their representatives, the state, has the right and the duty to intervene. And that's why Section 507 lays out very specific requirements that the Attorney General be notified and be given an opportunity to be present, present their own evidence, and ask their own questions at the hearing to determine whether a summons or warrant shall issue. Although Section 507 makes no explicit reference to the Attorney General being able to intervene and, in fact, having the ability to withdraw a charge once they've intervened, McHale makes it clear that they absolutely have that power as a matter of common law principle, and also points out the fact that nowhere in the criminal code does it indicate that the Attorney General has the right to withdraw a charge, yet clearly they do. It's done every day. So again, if you're laying a private prosecution and you don't want the state to intervene and immediately withdraw the charge, you need to have it backed up with solid, direct evidence, or very compelling circumstantial evidence. But if you have the evidence, it can be done anytime. It's your right, and some might say it's your duty to bring private prosecutions in situations where the state is either unwilling or unable to for whatever reason. Now, certainly, you don't need a lawyer to do this. You may consider hiring counsel because of their experience and their knowledge of the law in crafting a firm prosecution to ensure that that case is ironclad and won't be withdrawn by the state. But as always, that's your decision. This video is not legal advice. If you need legal advice or you're considering a private prosecution and you want some specific advice on how to make that happen, I would recommend that you consult a lawyer. You can call another lawyer or you can call myself. My 1-855 number is below, as is my website. I offer a free initial half-hour consultation. After the first half hour, I do have to charge for my time. If you have any recommendations or questions or things you'd like to see me cover in a future video, please leave a comment in the comments section below. And if you found this video at all helpful or informative, please consider liking, sharing, and subscribing.